Hello friends, good morning and welcome to the YouTube channel of TechSarge where we share legal, financial and taxation matters with you. आज हम बात करने वाले हैं CRPC के एक नए कॉन्सेप्ट के बारे में एंड दिस कॉन्सेप्ट विल बी ऑल अबाउट FIR. तो सेक्शन 154 टॉक्स अबाउट फर्स्ट इंफॉर्मेशन रिपोर्ट. आपने जनरल सुना ही होगा टर्म्स हमेशा फिल्म्स में, टीवीज में. आज देखते हैं कि ये है क्या चीज़. आई प्रेजेंट द आंसर्स इन अ व्यू so that you can write in your exam. तो द टॉपिक जो आज हम बात करेंगे, it is write an explanatory note on the meaning, utility and significance of the FIR. What is the effect of delay in filing FIR? The procedure to be followed when FIR is made in respect of cognizable and non-cognizable cases. आइए देखते हैं meaning of FIR. The term FIR has nowhere been defined under CRPC. It may however be defined as under. मतलब टेक्निकली इसका डेफिनेशन सीआरपीसी में नहीं है. हाउएवर बी डिफाइंड एज अंडर. इट इज इंफॉर्मेशन दैट इज गिवन टू द पुलिस ऑफिसर. इंफॉर्मेशन मस्ट बी रिलेटेड टू अ कॉग्निजेबल ऑफेंस. It is an information first in point of time. It is on the basis of the information the investigation into the offense commences. The information given to the police officer and reduced to writing as required by the section is called the FIR. FIR is not mentioned in the code, but a report recorded under this section is known as first information report. Clear? Where FIR is lodged. The general rule is that ordinarily the information about the offense committed to is to be given to the police station having territorial jurisdiction where the offense has been committed. But this does not mean that it cannot be lodged elsewhere. जरूरी नहीं कि हर बार पुलिस स्टेशन जाके ही लिखाया जाए, और भी बहुत जगह हो सकता है. In the state of Andhra Pradesh versus Pumati Rumbe 1993, the police constable refused to record the complaint on the ground that the said police station has no territorial jurisdiction over the place of crime. ये सीन तो मैंने फिल्मों में देखी है. अजय देवगन की फिल्म थी शायद, ये पता नहीं कोई और, कि उसकी माँ जाती है रिपोर्ट लिखाने तो मना कर देता है कि ये हमारे थाने में नहीं आता. काली चौकी, शैतान चौकी, पता नहीं कुछ था. It was held by the Supreme Court that refusing to record the complaint was a dereliction of duty on the part of the constable, because any lack of territorial jurisdiction could not have prevented the constable from recording information about the cognizable offence and forwarding the same to the police station having jurisdiction over the area in which the crime was said to have been committed. तो पुलिस वाला ये बोल के नहीं मना कर सकता कि मेरा जुरिस्डिक्शन नहीं है. आपका काम है रिपोर्ट लिखाना, पुलिस वाले का काम है रिपोर्ट लिखना. तो एज पर प्रोटोकॉल पुलिस ने वो रिपोर्ट लिखना है, और लिखने के बाद जहाँ भेजना है वो अपना भेजता है. That is his lookout. You have reported the crime. That's it. Object क्या होता है FIR का? The object of insisting upon prompt lodging of the report to the police in respect of commission of an offence is to obtain early information regarding the circumstances in which the crime was committed. Delay results in embellishment and the report gets bereft of the advantage of spontaneity. There is also danger of introduction of a colored version, exaggerated account, or concocted story as a result of deliberation and consultation. Though the importance of FIR made promptly cannot be minimized, the mere fact that it was immediately made after the incident cannot rule out any embellishment in the version about the incident given by the prosecution. Where the FIR was found to have been written after an inquest report was prepared, it was held to have lost its authenticity. मतलब कांड हो जाने के कुछ देर बाद या कुछ दिन बाद हम अगर लिखाते हैं तो उसमें वो स्पॉन्टेनिटी और जेन्युइनिटी नहीं रहता है. देयर इज हाई चांसेस दैट इट हैज बीन मैनिपुलेटेड और यू कैन से इन्फ्लुएंस्ड. आगे बढ़ते हैं. Where oral complaint disclosing commission of a cognizable offence has been made and police investigation has started on its basis, and later on a second report is made in writing, it has been held that the written report has to be considered as statement under section 161 and not as a FIR. It cannot be used to corroboration of the evidence of informant. Golajala Reddy versus State of Andhra Pradesh. The first information report need not contain each and every minute incident that occurred either prior to or subsequent to an offense. A message sent by telephone to the police officer and recorded by him in this station diary which discloses information regarding cognizable offense and amounts to the first information report. Essentials of FIR. Where the first information given to the police officer was reduced into writing after making a telephone call to the main police station, the report was held to constitute FIR. Where a telephonic message only conveying the fact of the killing was given, it only amounted to giving information as to the commission of the offense and could not be used as substantive evidence. The question of whether such a message would constitute a first information report will depend on the relevant facts and the circumstances of the case. A first information report which does not allege or disclose that the essential requirement of the penal provision is prima facie satisfied cannot form the foundation or constitute the satisfying point of a lawful investigation. Clear? A cryptic and anonymous telephone message which did not clearly specify a cognizable offense cannot be treated as FIR. The mere fact that such a message is first point of time does not by itself assume it to be FIR. अगर कोई बंदा ऐसे चुपके से पुलिस को फ़ोन करता है कि हेलो मैं खबरी लाल बोल रहा हूँ, आज शाम को 4 बजे मैंने बम लगा दिया है यहाँ पे, तो वो FIR नहीं है. That can be a threat but at least not a FIR. A first information report is no substantive piece of evidence and can only be used to corroborate the statement of the maker under section 157 of the Evidence Act or contradict it under section 145 of the Act. But the omission of the important far affecting the probabilities of the case are relevant under section 11 of the Evidence Act in judging the veracity of the prosecution case. Cannot be used as evidence against the matter at the trial if himself becomes an accused, not to corroborate or contradict, discredit other witnesses. Its value must always depend on the life of circumstances of a given case. This information where recorded is the basis of the case set up by the informant. The statement not necessarily be an eyewitness account of what the informant has actually seen. आगे चलते हैं. Importance of FIR. It is of very great importance to know what was said at first before there is a time for the fact to be forgotten or embellished. The memory is then fresh, and if the statement is made soon after the occurrence, there would be no opportunity left for successful fabrication. It is an important and vital piece of evidence for the purpose of corroborating the oral evidence adduced at the trial. Its importance can hardly be overestimated from the standpoint of the accused. Evidentiary value of FIR. It is a settled law that FIR is not a piece of substantive evidence. It is not the evidence of the fact which is mentioned. It is also well established that unless a first information report can be tendered in evidence under any provision contained in Chapter 2 of the Evidence Act, such as a dying declaration under Section 32(1) as to the cause of the informant's death or part of the informant's conduct under Section 8, it can ordinarily be used only for the purpose of corroborating, contradicting, or discrediting under Section 157, 145, 155, Evidence Act, etc. Evidence Act, its author. If examined and not any other witness, it cannot be relied upon when it is not tendered by the prosecution in accordance with Section 157 of the Evidence Act. आइए देखते हैं, what is the effect of delay in filing FIR? The object of insisting upon prompt lodging of the report to the police in respect of commission of the offence is to obtain early information regarding the circumstances in which the crime was committed, the names of eyewitnesses present at the scene of occurrence. Quite often result in embellishment, which is a creature of afterthought. On account of the delay, the report not only gets the benefit of the advantage of spontaneity, but danger also creeps in with the introduction of a colored version, exaggerated account, or concocted story as a result of deliberation and consultation. It is therefore essential that the delay in lodging the FIR should be satisfactorily explained. Where prosecution fails to explain delay, FIR should be viewed with suspicion. If delay in lodging the FIR is explained, it loses no weight, but the FIR on account of the ordinary delay cannot be relied upon with reference to supplementary statement which was inadmissible in evidence. Information in cognizable cases. According to Section 154, every information relating to the commission of a cognizable offence, if given orally to an officer in charge of a police station, shall be reduced to writing by him or under his direction, and be read over to the informant shall be signed by the person giving it, and the substance thereof shall be entered in a book to be kept by such officer in such form as the state government may prescribe in this behalf. A copy of the information as recorded under subsection 1 shall be given forthwith free of cost to the informant. Any person aggrieved by a refusal on the part of a officer in charge of a police station to record the information referred to in subsection 1 may send the substances of such information in writing and by post to the superintendent of police concerned, who, if satisfied that such information discloses the commission of a cognizable offence, shall either investigate the case himself or direct an investigation to be made by the police officer subordinate to him in the manner provided by the code, and such officer shall have all the powers of an officer in charge of the police station in relation to the offence. Information as to non-cognizable cases according to section 155. When information is given to an officer in charge of a police station of the commission within the limits of such station of a non-cognizable offence, he shall enter or cause to be entered the substance of the information in a book to be kept by such officer in such form as the state government may prescribe in this behalf, and refer the information to the magistrate. No police officer shall investigate a non-cognizable case without the order of a magistrate having power to try such case or commit the case of a trial. Any police officer receiving such order may exercise the same power in respect of the investigation except the powers to arrest without warrant as an officer in charge of a police station may exercise in a cognizable case. Where a case relates to two or more offences of which at least one is cognizable, the case shall be deemed to be a cognizable case, notwithstanding that the other offences are non-cognizable. कहने का मतलब कि अगर एक केस होता है जिसमें बंदा किसी के घर से उसने एक वास चुराया, गमला वास चुराया, ठीक है, ये नॉन कॉग्निजेबल ऑफेंस हुआ, लेकिन वो गमला चुरा के ले जाके किसी के सर पे मार दिया और वो वहीं मर गया, ये कॉग्निजेबल हुआ। तो एक ऑफेंस जो था उसका वो नॉन कॉग्निजेबल था, एक ऑफेंस जो है वो कॉग्निजेबल है, तो इसको कॉग्निजेबल की तरह ही ट्राई किया जाएगा दोनों केस को कंक्लूसिवली, ठीक है। Police officer's power to investigate cognizable case. According to section 156, any officer in charge of a police station may, without the order of a magistrate, investigate any cognizable case which a court having jurisdiction over the local area within the limits of such station would have the power to inquire into or try under the provision of chapter 13. No proceedings of a police officer in any such case shall at any stage be called in question on the ground that the case was on which such officer was not empowered under the section to investigate. Any magistrate empowered under section 190 may order such an investigation as above mentioned. That was all for FIR. I hope you have liked the video. अगर आपको वीडियो पसंद आया है तो लाइक करें, सब्सक्राइब करें हमारे चैनल को, और कुछ आपको जानना है, कुछ और टॉपिक्स आप चाहते हैं हम शेयर करें तो प्लीज़ कमेंट. If you need the PDF file of this video of this presentation, just write your name, college and email address. We'll mail you this PDF. Okay, thank you.